Excellences, Mesdames et Messieurs.
Your Excellencies, dear committee members, dear colleagues, it's a pleasure for me to welcome you to the 544th meeting of the Committee on Enforced Disappearance. Today, we will continue our review of the report submitted by Benin pursuant to Article 29, Paragraph 1 of the International Convention for the Protection of All Persons from Enforced Disappearance. And it's a pleasure for me to once again welcome His Excellency, Minister Yvonne Detchenou, head of the delegation, and His Excellency, the Ambassador Angelo Dan, as well as the rest of the Beninese delegation who are both in the room and also online with us from Cotonou. This morning, we will turn to the second round of questions posed by the committee to the State Party based on the list of issues submitted to which the delegation provided written replies. The second round of questions will focus on Articles 16 to 25 of the Convention. And we will begin with the first round of questions lasting 40 minutes. And thus, as usual, I would like to give the floor, first of all, to the country rapporteurs, but I would invite other committee members, if they so wish, to raise their nameplates to ask questions of the delegation. So I'll give the floor to the rapporteur, Mr. Juan Alban Alain Castro, and Mr. Mater Diop. We'll start out with Mr. Diop, please. You have the floor, sir.
Merci, Monsieur le Président.
Thank you, Chairman. First of all, heartfelt greetings to the delegation with us and the delegation following us online from Benin. As pointed out by the chair, today we're going to consider Articles 16 to 25 of the Convention. Today we'll be talking more about the prevention of victims. I won't be very lengthy today. To prevent and investigate disappearances related to trafficking in persons, particularly at the threefold border region between Nigeria, Benin, and Togo. I'd also like to ask the state of Benin about the measures it has implemented or is implementing to protect nationals of Benin who are outside of the borders of the country in relation to human trafficking and the risk of a disappearance in that context. In addition, on that same point, I'd like to ask the state whether there are specific protocols in place for cross-border cooperation when there is a suspicion that victims of human trafficking are elsewhere in the territory of another state. And to tie in with that issue, because this is to do with victims' rights, I'd like to ask the distinguished delegation of Benin how it can explain the recent situation of the search and investigation into victims of human trafficking in Benin, despite the fact that trafficking in persons continues to be a risk. And similarly, because this links in with victims' rights, now the services provided to victims of trafficking and smuggling, these may be shelters, legal aid, psychological support. Why have all of these been reduced, and why are they no longer a priority? I'd like to know whether there's any national strategy in place to overcome this situation, and ensure that victims enjoy appropriate support, bearing in mind their situation, above and beyond the prosecution of the perpetrators and the determination of the consequences and the sanctions provided for in law. Now, also on the issue of victims' rights, in your response to the list of issues, you refer to an early warning system, the WAPIS system, and the actions of the National Interpol Agency to carry out urgent searches. But I think it would be important to know how these early warning systems are triggered and how you promote the inclusion of the Interpol Agency for urgent searches. Who can use those mechanisms? I'd like to know whether civil society, which is organized, and families of disappeared persons have access to those mechanisms, and how so. From a procedural standpoint, we would like to know how the earlier warning system works in practice, and also the WAPIS system, the West African Police Information System, as well as the National Interpol Office in terms of developing urgent search systems. I'd also like to know who can activate those mechanisms, particularly because they're international in nature. We have the West African Police Information System. Is this triggered by the Beninese authority once it receives information about a possible disappearance, or can the victims and their relatives approach the WAPIS system and activate the urgent search mechanism? I think it would be important to clarify that point. Also, tying in with victims' rights and bearing in mind the context of insecurity in the north of the country, there are reports of abductions and disappearances committed by non-state actors. Now, above and beyond the fact that Benin has informed us that there are no enforced disappearances, the information this committee has shows an increase in disappearances committed by non-state actors. Over 100 incidents have taken place in recent years. The state itself, in the documents submitted to this committee, that there are early warning systems and cooperation systems that I've just referred to. You've got the WAPA system, you've got an Interpol agency, but there's no information about the specific measures that have been implemented to prevent the occurrence of these disappearances, which are committed by non-state actors. Particularly if we bear in mind the fact that even in situations where there's no state participation, Article 3 of the Convention sets minimum standards for states. This is to do with investigations and, in parallel to that, the search. But of course, when there's an indirect participation of the state, these are no longer disappearances under Article 3 of the Convention, but rather disappearances pursuant to Article 2, which may have occurred with the acquiescence of the state. I am not here asserting that this is the case, but I'd like to ask what strategies and measures have been adopted to grapple with the disappearances committed by non-state actors in the north of Benin, to avoid these acts from being enforced disappearances because of the indirect involvement of the state, because of the participation or acquiescence of state agents, or the acquiescence of the state. How is the population protected vis-a-vis these events? How is information gathered when the perpetrators are non-state actors? And along the same lines, It would be important to know what safeguards are being implemented to avoid disappearances in the context of anti-terrorist activities, which are precisely carried out in the north of the country. How can you ensure that innocent victims do not end up in the struggle? How do you ensure that they are not harmed or persecuted within the context of anti-terrorist activities? I'd like to know whether members of the Fulani community have been affected disproportionately in the anti-terrorist activities, and if this is the case, what mechanisms are in place to address the situation of members of the Fulani community? I'd like to know, how does the state of Benin ensure that anti-terrorist activities and efforts do not compromise the rights of certain ethnic minorities, or indeed violate their rights? In addition, bearing in mind that the replies provided state that any crime may be subject to reparation measures, which may be economic in nature. In some cases, the children of persons who have been disappeared receive other forms of reparation, such as psychosocial support. How do you guarantee the rights of victims and their family members to having access to these reparation mechanisms? What mechanisms need to be activated to have access to the reparation, in addition to economic cooperation and psychosocial support planned domestically? Are there other forms of reparation? I'm thinking of satisfaction measures, measures of non-reoccurrence, non-repetition in the future. And directly related to that, how do you ensure that the rights of victims have access to the truth? Article 24 of the Convention is the very first hard law standard which explicitly recognizes the right to the truth. So we would like to know what mechanisms are in place in your domestic legal system so that victims can know the truth about the fate of the disappeared person. And to what extent is there a public dissemination of this information so that society as a whole knows about what has happened to the person and who the perpetrators of the disappearance are, under what circumstances did the disappearance take place, what effects did the disappearance have? Now, also related to the rights of victims, I'd like to ask the Beninese state about the mechanisms in the domestic legal system to ensure the active participation of victims in search procedures and investigation procedures. Now, there has been a specific guideline issued by this committee in April 2019. These are the guiding principles to search for disappeared persons. In search procedures, the intervention of victims is allowed, that is to say, the loved ones or relatives of disappeared persons, because the notion of a victim is a very broad sense under Article 24 of the Convention. And this participation doesn't only refer to a search procedure, but also the investigation procedure as well. Investigation doesn't simply mean that the state periodically provides information, but there's a need to actively contribute to efforts to be present in search procedures as well. And here, I'd like to ask if there are any specific examples of measures that the state has adopted to guarantee victims' participation and measures adopted by the state to provide reparation to victims to date. Now, of course, we understand that from the viewpoint of the state, there are no cases of enforced disappearance. Turning now to the issue of the training of officials on the convention and the dissemination of the convention's content. The initial report of the state reports that human rights training is periodic and that there are plans to include specific modules about the problems of enforced disappearance and the Convention on Enforced Disappearance in the training programs of criminal law officials. And in the reply to the list, also points out that these training models are still at the planning phase and that there's no timeline or information about the content to be included in those training processes. So bearing in mind that some time has gone by since the submission of the replies to the list of issues, I'd like to ask the state about the current situation in terms of preparing for these training programs about enforced disappearance and also the content of the convention. Do you already have a timeline to implement this training program? Do you have any idea about the content that will be included? And in addition to that, I'd like to ask how you plan to assess, after the training session has taken place, the efficiency and effectiveness of the training program. Above and beyond this, and bearing in mind that the state's obligation isn't just to train a person, but also to disseminate the content of the convention, I'd like to ask the state of Benin whether it has rolled out awareness-raising campaigns that are public in nature, generally speaking, about the phenomenon of enforced disappearance and the content of the convention. Now, given that some time ago I was just talking about the situation in the north of the country, is this awareness campaign aimed at the ethnic minority groups and also the terrorist organizations operating in the north of the country? Have these persons been informed about how they can activate these measures at the local level for investigation and research, and how they can be provided with reparation? And just to sum up now with my questions, I have a couple of questions in relation to children vis-à-vis the phenomenon of enforced disappearance, as set out in Article 25 of our convention. Benin, in the documentation submitted to this committee, that it doesn't plan to include the crimes that Article 25 refers to in its criminal legislation. And it has stated that its children's code provides for the cancellation of adoptions which have been obtained illegally or fraudulently. However, it hasn't provided any details about the procedure in place to cancel these adoptions and the mechanisms to protect the identity of the children. These may be changed within the context of an enforced disappearance, apart from a fraudulent adoption procedure. And given that armed groups are present in the north of the country and the risks faced by the situation, you haven't told us about that, the risks to the Fulani community. You haven't told us about the mechanisms implemented to prevent the forced recruitment of children into the ranks of these armed groups. And so I would like to ask the state how you plan to strengthen the legal framework, because you have already told us that there are no plans to incorporate new criminal offences in the criminal code. How do you plan to strengthen the legal framework to prevent and punish the removal of children and the substitution of children's identity, the forced recruitment of children by armed groups? I'd also like to ask how the specific procedures being developed to cancel an adoption or a guardianship model if enforced disappearance has occurred. What proof is required for that type of case, and what timeline is allowed for this procedure to ensure that the procedure is swift and efficient? And also on the same issue of the protection of children, let me ask if there have been any investigations or if there are any mechanisms in place to investigate and provide a remedy to victims of historic cases of illegal adoptions and falsification of one's identity. And I'm thinking particularly within the context of the international trafficking of children. or smuggling of children. Has the Beninese state set up a mechanism to determine the truth or reparation via administrative channels to victims who have been affected by the illegal adoption of children within the historic context? And are there any legal reform procedures in place so as in the future to prevent abuses in the adoption systems in Benin?
And to close now, and given the time that we have left, I'm certain also that other colleagues might have some questions to ask as well. I would like to ask the following questions. They have to do specifically with civil society, free speech, and victim representation. How has the state ensured that CSOs working on matters related to enforced disappearance of persons, trafficking and smuggling of persons can support the victims, cooperating freely with any sort of risk or limitation? I should also like to know what limitations or what limits currently exist as regards free speech or freedom of association. And do these matters affect the possibilities of victims of enforced disappearance and their representatives to organize or to publicly call for support in cases of enforced disappearance? Now, lastly, also, does the government include CSOs and victims associations in the processes of policy design in matters that are addressing enforced disappearance? Public policies, for example, in the area of migration, public policies in the area of trafficking in persons, of smuggling, human smuggling, and public policies in general as regards human rights protection. Those are the questions that I wanted to ask the delegation of Benin. Mr. Vice Chairman, thank you very much.
Merci beaucoup, chers collègues.
Thank you very much, colleagues. I would now turn to other members of the committee to see whether anyone would like to raise their placard to ask additional questions. Two questions. I have two questions. My first question actually can be broken down into numerous sub-questions. Reading the report, which was very informative, that was put together by the Special Rapporteur on the Protection and Promotion of Human Rights and Fundamental Freedoms in the fight against terrorism during the visit recently undertaken to your country. And perhaps the state party has not had time to respond to that report. However, it is noted therein, or actually two items are noted in that I'd like to mention. First, paragraph 24, which is of import to this committee on enforced disappearance, in that paragraph addresses the guarantees of prevention of deprivation of liberty, Articles 17 and 18, and through to 20. And paragraph 24 says the following: this is transferred to the Parakou brigade, and the cases are undertaken in the Republican Criminal Division in Cotonou, and that these transfers generally take up to 24 hours, according to the Republican Police. However, it takes 5 to 8 days without counting the initial transfer. It is also noted that these transfers have lasted up to 15 days. This prolonged delay is explained by the fact that they go from police station to police station along the way, which brings the problem of them not being brought before, not remaining for judicial bodies. So that's a question that we're wondering about. We see this in numerous countries, actually, where the transfer from an arrest to a place of deprivation of liberty can take a certain amount of time. So the question has to do with the legal oversight that's organized during that transfer, during that phase. And also the compatibility of these practices with national legislation. And as regards the convention, when we look at the legality of a detention, there's the oversight issue, but there's also the issue of access of the family members to information on the whereabouts of the individual that's deprived of liberty. So the question is whether the delegation might be able to clarify to us the measures that are envisaged when it comes to addressing that concern expressed by that special rapporteur. Now, also, I'm also looking at paragraph 43 of the same report as regards isolation. Article 160 from a decree on the very same matter, which authorizes the penitentiary authorities to place people in isolation in 22 hours or more per day for 1 to 6 months for disciplinary matters of the third order, third degree. The rapporteur, special rapporteur, notes that that this happens way beyond the 15 days set forth in Article 43 of the Mandela Rules. This is a legal regime and not covered by Article 17, but it is considerable, the amount of time there, particularly when we take into account the possibility of an individual or lack thereof to communicate with their family. And this period of time just does last a very long period of time. We also would like to ask the delegation about measures that might be taken to respond to that concern as well. Again, I'm citing the special rapporteur. Now there's another question. My colleague Juan Pablo Alban Alencastro mentioned this, and that is the issue of prevention of the disappearance of children, perhaps enforced disappearance, perhaps then leading to an adoption under illegal conditions under Article 25 of the Convention. There are prevention measures that are essential, but sometimes it's difficult to implement them in some states. This situation of registering children at birth is relevant before the civilian authorities. And that measure is aimed at preventing the abduction of children. So where is Benin on the implementation of this crucial protection measure that includes birth registration? And what measures are taken by the state partner to ensure that there's birth registry immediately upon birth? So that's all I have. I would ask my colleagues if they have additional questions that they would like to ask at this time. I see that there are no requests for the floor. That being the case, we are at the end of this first cluster of questions. I thank the rapporteur. We will now have a break, 15 minutes, that will allow the delegation to organize its responses. Thank you kindly. See you soon.
Séance est suspendue. Chers collègues,
Dear colleagues, Excellency, ladies and gentlemen, we will now return to our meeting. We will be returning to the consideration of the report submitted by Benin under our convention. The first series of questions, the first cluster of questions were asked by the rapporteurs and the members of the committee. I would now ask the delegation if they might, over the next 45 minutes, respond to those questions. Thank you very much. Thank you, Chair. I thank you for having afforded us the floor. And I would like to propose that our colleagues online from Benin might take the floor to address numerous items based on the discussion we've had. I would like to ask that the committee give the floor to the Benin Commission for Human Rights. This is an independent body. It is our NHRI. It will be able to offer specific responses and clarify numerous points. And afterwards, I can take the floor and sum up on a number of items that might go beyond the framework of the dialogue on the convention with that NHRI, and it addresses other subjects that were addressed. Thank you very much. So if I might, I would give the floor directly to Cotonou.
Absolutely, Minister. Ladies and gentlemen, good morning. Welcome. I hope you can hear us. I therefore give you the floor.
alors nous, est-ce qu'on... Alors, il faut mettre le casque. Est-ce qu'on les entend bien?
Non.
Alors, on ne vous entend pas.
So far we cannot hear you, says the chair to Benin. Turning to the technical.
Alors, on a eu un début de...
Well, we had the beginning of some sound, but with some echo.
Voilà. Alors, maintenant, nous vous entendons.
We can hear you now, says the chair. You have the floor.
Merci, Monsieur le Président.
Thank you, Chair. I'm the director. I will speak to matters pertaining to non-refoulement. May I make clear that the 2022-31 of the 20th of December 2022 on the status of refugees and stateless persons in the Republic of Benin prohibits when a person who in their normal life is involved in anything be the subject of reform. Well, this is an administrative decision taken by the Minister of the Interior and Public Security, who, when the person is in that situation, they can appeal or oppose the decision for her to be refooled or extradited, and it has suspensive effect before the Commission on Stateless Persons and Refugees. So until the decision is handed down, the refoulement decision cannot be implemented. So nationally and domestically, that is the instrument the Benin has to protect people against refoulement. The other concern has to do with the register, which governs traceability along the legal process from the police station to the examination phase to detention. How do we ensure that every person is traced, accounted for throughout the legal proceeding? Now, what is being currently set up is a single register which gives information about those people along the custodial chain. to ensure that there's one single register and not several registers. The aim is for us to have this single register that covers the moment of apprehension, detention in police custody, all the way to conviction and sentencing. This register, you asked, is it manual or is it systematized, digitized? Well, it will be electronic. It will be an e-register. Currently, we have several different manual registers, but at the end of the day, this register will be an e-register designed to trace the location of the detainee throughout the chain of custody. Thank you.
Merci beaucoup.
Thank you very much. Lia Norbert Adjon is my name, Director of Criminal Cases and Pardons. On the extradition procedure, it is a judicial procedure in nature, where all guarantees and respects for the defense are guaranteed, all are observed. The procedure begins with the Attorney General being apprised of the case. He then, or she, refers the case to the appeals court examination chamber. That chamber considers the case and is empowered to hand down a decision favorable to the decision, so granting the decision. That decision is sent to the Garde des Sceaux, the Keeper of the Seals, or Minister of Justice, who then takes the case to the Cabinet, the Council of Ministers, for the extradition decree to be adopted. On police custody now, garde à vue in French, how many times can it be extended and who extends it? It was the question. Well, the decision on police custody is taken by a criminal investigation officer, or a CIO, but Article 62 of the Code of Criminal Procedure stipulates that from the adoption of the police custody measure, the CIO is obliged to inform the general prosecutor or the director of public prosecutions, who can give the CIO instructions about the extension, or rather the release of the suspect, or the extension of the length of police custody or remand. In any case, beyond 48 hours, the CIO must present the suspect in custody to the Director of Public Prosecution, failing which the CIO will be disciplined. Or the appeals chamber, examination chamber might hand down penalties. The Director of Public Prosecutions, or Procureur de la République in French, is the competent authority, if grounds justify it, extend the remand length or the length in police custody, and that extension is notified to the person who is in police custody. The question was also, when can this person communicate with his or her relatives? Well, as soon as the police custody measure is decided upon, then his or her rights are notified to him or her, including the right to contact their relatives.
Merci beaucoup.
Next speaker, thank you very much, Mr. Chairman. Divisional Commissioner Olysse François Lopé, Director General of the Penitentiary Agency of Benin, the prison service. I would like to answer the question put to us regarding the organization of the visit by the judicial authorities and human rights organizations to custodial facilities. Well, the legal framework for these visits is established by Article 808 of the Code of Criminal Procedure, which stipulates that the examining magistrate, the president of the indictment channel, and the president of the chamber for custody, and as well as the director of public prosecutions, all of these people can visit custodial facilities in the country as well. Any natural legal person to whom international conventions which the Republic of Benin is party to is empowered to visit custodial facilities or any other of their place of deprivation of liberty in Benin. This provision was also supported by decree, the sound was lost for 3 seconds there, but decree 153 that it applies. Therefore, the human rights organizations in Benin have access to custodial facilities since the measures were lifted, and the Benin Human Rights Commission, as well as the Ombudsperson, as well as the ICRC, as well as the Department for Human Rights, and any other NGO who has got a visits agreement authorization can visit places of deprivation of liberty in Benin. If I may, I will also now move on to the issue of isolation, detention and isolation, to say that pursuant to Decree 2024 15-153 of the 9th of October 2024 on the organization and the rules of procedure of the penitentiary establishments in Benin, there are 2 types of isolation: the isolation, protection isolation, and judicial isolation. So the judicial isolation is decided upon by the judge and is designed for evidence to be gathered as the case progresses in order to avoid contact between the accused, the detainee, and other persons which could harm the case. Now, back to the protection isolation, the first case, there are 2 forms, either because on health grounds or on security grounds, it can be decreed. So isolation is not a disciplinary sanction. Isolation, the protection isolation that is ruled by the judicial authorities, but under the court supervision. That's what I can say on those 2 matters. Thank you.
Merci. Merci.
Thank you. Inocencia Lacourville Montero is my name, Director of Cooperation and Mutual Judicial Assistance. I will raise matters pertaining to the role of Interpol in the case of enforced disappearances. Let me say that we have tools and trainings which the Interpol proposes. We are a member of Interpol, and therefore we get rapid support from Interpol on these matters. For example, we use the Interpol legal notice that applies to a disappeared person. So when a case of enforced disappearance is brought to our attention, the specialized units in our country will not hesitate. They will straight away turn to this very effective police cooperation mechanism, which works 24/7, and it enables the state to very expeditiously and comprehensively disseminate the information about the disappeared person to identify him or her. We should also say that the organization proposes also a orange notice, which applies when there's a threat of an enforced disappearance, and we can use that mechanism when there is a suspicion that a person might be disappeared. It's a very effective tool, this orange notice, thanks to which we can notify the other countries that are members of Interpol. With regards to trafficking now in persons, we are very committed to combat trafficking in persons. And to be successful in that endeavor, we've ratified several international conventions on trafficking. And domestically, we also have a preventative legal framework and a very strong legal framework, institutional framework, which attests to our determination to combat this phenomenon. In our criminal code, for example, we have provisions, Article 499 to 504, 499 to 504 on trafficking in persons, and which criminalize trafficking with penalties ranging from 5 years to 20 years in prison. Once again, reflecting our absolute determination to end impunity for this devastating crime. As far as children are concerned, we've gone even further. Domestically, we've adopted Law 2004 on declassification of minors in Benin. All of this legal machinery allows us to afford adequate protection to children and adults who might become victims of trafficking. And on back to international cooperation, which could involve several countries at one given time, Benin, both on police cooperation and judicial cooperation, has created all the structures that are needed to effectively and proactively act to counter threats in this particular area, namely the area of trafficking. Thank you, and disappearance. Thank you.
Bonjour, Monsieur le
Chair, good morning. Greetings to the whole of the committee. Arnaud Tofoun is my name. I'm a magistrate and director of legal aid and assistance for childhood affairs in the Ministry of Justice and Legislation. I'd like to answer the questions put to us about children. I like to raise 3 points. Number one, on mechanisms to prevent the forced recruitment of children in armed groups. Now, on that particular point, in Benin, Article 204 of the Childhood Code prohibits explicitly the participation of children in the activities of armed groups and armed forces. This article says no child can be involved in an armed conflict or participate or be enrolled in the armed forces or groups in any way or another. So the Benin state is therefore determined to avoid the participation of our children in the activities of armed groups or forces. This is a clear determination, and from that point of view, you have nothing to worry about. We are planning to sanction the forced recruitment of children in armed groups a priori. Well, it has been claimed that we have planned to do nothing in this area, but that is a mistake. Article 499, aforementioned, following, as well as the relevant provisions of Articles 464, enable us to say that the practices in connection with forced recruitment of children, or designed to enroll them in armed groups, can be deemed to be crimes against humanity, or at any rate, crimes pertaining to trafficking, because they're underpinned by concepts of slavery and practices equatable to slavery. And these practices are punished and will be punished by judges and magistrates. So when a disappearance takes place, what is the procedure? Well, in our republic, we do not have the concept of annulment, that is annulment of adoption procedures. But we do have another concept close to annulment, which is revocation. Now, for revocation in cases of adoption, well, for simple adoption can be revoked if there are serious grounds for revocation. For example, if adoption has taken place, but the adoption is linked to an enforced disappearance, then that adoption can be revoked. But we have full adoption that is irrevocable. That adoption, that form of adoption, cannot be revoked. However, there are Article 670 of the Code of Criminal Civil Procedure enable us to revise an adoption decision when it has been established that fraud took place when the adoption was ruled, and the children therefore are well and fully protected by all of these instruments, which our courts respect. To conclude, as far as I know, as technical director of my organization, there are no cases of enforced disappearances in Benin linked to adoption within the meaning of the convention, and as far as children are concerned. Thank you very much.
La question. Monsieur le Président, je vous remercie.
The Minister of Justice in Geneva interrupts. Thank you very much. Before we give the floor back to Cotonou to talk about Wapis and Sipao, which still hasn't been addressed, and on that, can I ask the BCIG and the CTSP to intervene? But before, could we give the CBDH the floor here in Geneva on police custody and guarantees for rights of persons who are the subject of a criminal inquiry or investigation? Thank you, Chair. Absolutely, Minister. Says the Chair. I'll give the floor to the Benin Commission for Human Rights, the National Human Rights Institution, therefore, Independent National Human Rights Institution of Benin, with us. Obviously, sir, as head of delegation, you are totally at leisure to give the floor to whomsoever you wish in the room. So you have the floors, sir. Thank you. Our institution is totally independent, as you said. We have A status under the Paris Principles. We would like to recall that in the context of its mission, there are certain elements that are very dear to us, and thanks to advocacy and discussion, we've been able to improve our performance. I begin with police custody. As indicated in our texts, as regulated by our texts, our constitution itself, in fact, provides organization for police custody arrangements. And it is on the basis of what the Constitution says that we monitor police custody. The Constitution has organized police custody arrangements by explaining in its article number 18, last paragraph, what authority the CIO must report to, and the CIO, criminal investigation officer, can only renew the police custody if he presents the accused person to a judicial body who can not extend police custody beyond 8 days. That's the maximum of remand. And we monitor that deadline, we, the National Human Rights Institution, and that is a standard procedure which is respected today. Now, what crimes can justify an extension? Well, Article 61 of the Code of Criminal Procedure specifies what these crimes are, and it says that the general prosecutor can decide on the extension of police custody only in exceptional cases such as crimes against humanity, such as general crimes in general, offences against minors, trafficking and use of drugs, and other offences, specific ones such as terrorism, etc. So the legislator has already, in the Code of Criminal Procedure, established this list, and we and the Benin Commission for Human Rights monitor this, and so far we find that this measure has been respected nationwide. With regards now to isolation in prisons, isolation is regulated by the aforementioned decree, which you've heard about, but since the 9th of October 2024, the government has adopted another decree, 2024, 1153, which the Director General of the Prison Service referred to, which clearly organizes the measures applying to isolation. Now, isolation time is also regulated within the rules of procedure of individual custodial facilities in Benin. Now, when our institution, given that we are a member of the Oversight Committee for the monitoring of sanctions handed down within custodial facilities, given that we are a member of this committee, we also monitor isolation in prisons. And we've written reports on isolation in prisons, advocating for the improvement of the system. We have understood that this deadline, these 8 days, is always respected. And when we sense or perceive that there is a chance that that deadline might be exceeded, then we flag it during our visits. Now, on our visits of police custody facilities, decree of the 9th of October, that 9th of October 2004, also organizes that police custody and how the police offices are organized, and civil society and NGOs, non-profit organizations who are empowered to do so, visit the police custody facilities. But our added value is that if such bodies are reluctant to be visited, then the organizations wishing to visit the police offices of police stations come to us for our support, and we intervene and overrule the reluctance of the police stations who do not want to be visited, which means that, once again, when organizations come up against barriers, they can turn to us, the National Human Rights Commission, and as we say, we intervene and ensure that prisons or police custody facilities can be visited and the rights of detainees be protected. So this is what we do within the Benin National Human Rights Institution.
Merci beaucoup, monsieur.
Thank you very much, sir, says the chair. And the chair gives the floor back to the head of delegation, who wishes to give the floor to someone else in the room. No, back to Cotonou, back to Benin, to add to the answers.
Merci, Monsieur le Président. Je suis le commissaire divisionnaire Denis Ougan, directeur du Centre.
Director of the Center for Public Security Documentation. The sound has just cut off, the interpreters say. West Africa. Since 2019, Benin has been party to this system, which the interpreter didn't hear. And the question was, do people have direct access to this aforementioned system? The answer is no. The protocol requires that the law enforcement authorities trigger that system, given that it's a police information system. Once again, though, however, when data protection issues are at stake, they can raise their concerns. Otherwise, the triggering of the system is exclusively the prerogative of the law enforcement authorities. Once again, the interpreters do not know what body this is being referred to. And the Ministry of Justice is in charge of the Public Security Documentation Center, which manages the CPAO nationwide. So we're talking about the CPAO. So the CPAO is designed to manage the regional platform. The sound was cut off again, say the interpreters.
Abuja,
In Abuja, during the 60th meeting of the head of ECOWAS. The sound was cut off again, say the interpreter.
as de cette plateforme
This platform has been accepted and validated. So the regional platform on the WAPIS is still not up and running. However, every country party to the WAPIS has an agreement with Interpol, and therefore, in the context of that early warning system, can directly disseminate from its national WAPIS system, publish information on the platform 24/7. That's what I could say on how the WAPIS works and how the authorities empowered to activate the research mechanism on this platform, regional platform, can act. Thank you very much.
Nous retournons la parole au garde des Sceaux.
Cotonou speaking, returning the floor back to the Garde des Sceaux in the Keeper of the Seas, Minister of Justice in Geneva.
Mesdames et messieurs, messieurs les rapporteurs,
Thank you very much. I'm going to endeavour to summarize some points and clarify some matters which remain pending. On refoulement, we have a law on statelessness and refugees passed, and new regulations on aliens, which further clarifies matters, confirming legal appeal and the suspensive nature of the appeal, and which enables or makes it possible to for the decision of the competent authorities to be appealed. The competent authority is the Ministry of the Interior when there are concerns. With regards to the detention register, once again, I reiterate and clarify that it's a recent one. It became effective on the 1st of January 2025. It is interconnected with all the judicial and police bodies of the country, which means that it is essentially fed into by these stakeholders. There is an interface making it possible for there to be monitoring of the decisions of the Ministry of Justice and ensure that the timeframes are respected by prisons. Given that the system is interconnected, it's totally integrated, thanks to which digitally the decisions taken by law enforcement authorities can be disseminated, as well as release decisions. So this information is generated and cross-matched, thanks to which detention is better managed and better overseen along the custodial chain. Therefore, we better harness today what is happening to persons who are in detention and about to be released, and we can better oversee parole and release on probation.
sur la garde à vue,
On police custody, once again, is regulated by the Code of Criminal Procedure. The length of custody is established by the Constitution, as you've just heard, namely 24 hours, which can only be extended in specific cases and can only be extended by a competent judicial authority upon physical presentation of the person, a person in police custody from the moment of his apprehension is entitled to all the laws enshrined in the Code of Criminal Procedure, and even before that he or she is apprehended can, or rather formally detained, can receive the support of a lawyer who will inform him about the procedures pertaining to questioning and police custody. All these matters are dealt with by the lawyer when he or she is present side by side with the detained person. The natural police custody time is specified, but on that particular matter, I would like to go off on a short tangent, Chair. You will have noted in the note, for example, in the report of the Special Rapporteur you quoted earlier on, comments suggesting that detention can be extended by the Public Prosecutor's Office. That is not the case. That is not the case. We, in our liaising of the rapporteur, had made that very clear. So I wanted to labour that point because I want you to be reassured that we had responded to the report of the Special Rapporteur on a number of points of law which are slightly inaccurate. and that was the case of the detention length and isolation. These notions weren't fully understood. In our law, we distinguish between isolation linked to protection and monitoring of the health of the person detained, and we have confinement subject to other measures, but still consistent with the rules you mentioned. So we've made comments to that effect, and we're ready to clarify further.
Alors, il y avait une question par rapport à...
There was a question as to when can a person communicate with their lawyer. Once the person has been arrested, they can require and have assistance from a lawyer, and this is put in place well before the ratification of the convention in 2017. This falls under the Code of Criminal Procedure, which is adopted in 2012. This law has been extended to the profession of lawyers, and I mentioned this yesterday under Regulations number 5, that is to say, access to a lawyer within the ECOWAS space. What are the authorities empowered to visit places of detention? We mentioned Decree 2004-53 on the organization of prisons, and we mentioned the various authorities that have access to it. We have the police authorities, the judicial authorities, the public prosecutor's office to visit places of detention and all prisons, the general prosecutor and others can conduct regular inspections. We have the administrative service of the Ministry of Justice, which also carries out monitoring on a quarterly basis. We have a Directorate for Human Rights under the Ministry of Justice, which also conducts those annual inspections. And lastly, we have a number of organizations who are accredited above and beyond the institutions of the Republic. And also now, some NGOs who, based on the various agreements and conventions we have with them, and based on the agreements we have, can have access to those visits and conduct those visits regularly. I'd like to turn to the question now related to non-state groups and reports of disappearances by non-state groups. Here I wish to point out that terrorism in Benin, well, we don't have any Nigeria, Benin, and Togo. We do have some agreements between Burkina Faso and Benin. Nigeria are in the east and the west. When it comes to terrorism, we basically deal with two situations. The first situation is an infiltration of terrorist groups in our territory to conduct specific attacks. And following those attacks, that we have a general operations in place to protect the country and the civilians against incursions and infiltrations. And then secondly, we have phenomena of crimes, criminal groups between Nigeria and Benin, or between Niger and Benin. And to address those situations, we have systems in our law where the judicial police intervene, as well as specialized units focusing on specific crimes. They investigate the situation, they enforce the law and enforce sanctions. So sometimes we have these issues of domestic crime, and sometimes this occurs amongst communities because of land disputes, for instance. Then there are also issues of the abduction of persons for the purposes of marriage. And it's the judicial police that intervenes there to settle matters. But we don't have any case in the sense of the wording of the convention where we have abductions or arrests, which would be cases of enforced disappearance. Now, when we have specific reporting as to a specific terrorist group or the commission of a specific offence, the judicial police intervenes in those cases. The person can be subject to an arrest. Now, we have a base, a unit, which is known as a brigade or a unit, an anti-terrorism unit. And there's a distance between those of 900 kilometers between the north and then the center. We have 500 kilometers. There are transports organized by pickup service over 24 hours, and the Special Prosecutor's Office for the terrorist crimes intervenes, first of all, to authorize the extension of police custody, which can run up to 8 days. There were exceptional situations regarding 1 or 2 cases, and because of a lack of resources, there was an extension of the timeline for custody. But those cases really are very exceptional in nature, and I don't think we can mention them here and say that they are a current practice or common practice. There's been a development in the judicial police, and announcements have been made. The specialized criminal brigade unit has been extended between the north, the south, and the center of the country so as to better deal with cross-border issues and to deal with offenses, terrorism, and organized crime in real time, as provided for today. So we provide a response in terms of human resources, financial resources, and also material and logistical resources, so that we can deal with the situations highlighted by the Special Rapporteur, and we can deal with offenses in real time, as well as the criminal conviction in real time of persons who belong to terrorist groups and involved in terrorism. And on that point, once again, I'd like to say that when a person turns to the headquarters of the center, this does not mean that they are completely disconnected from their parents and from their social settings, because we shouldn't believe that in the south of the country there are people who are arrested from the north. People can be arrested, and even if a person is in the prison in the south and they come from the north, they can receive visits from their family members, from their relatives, and sometimes they're visited by the community and by organizations who are in liaison with us for the purposes of information to ensure that individuals receive better treatment, particularly those involved in terrorist offences, and those who belong to terrorist groups. Now, on the issue of search and investigation, of course, we don't specifically involve the community in the investigation stage. The community is outside of that stage, and we will look at to what extent this can be made possible by the Code of Criminal Procedure. This is done exclusively by the Judicial Police Authority. No other authority and the magistrate can intervene in the course of the inquiry and then the management of judicial investigations. Organizations can, of course, provide information, and perhaps we could share some information with them to have feedback and guidance about the investigation, but they're not directly involved in the inquiry. However, they can be involved in the search. And some NGOs, in collaboration with us, are involved in the search for individuals when information is provided, or we have issues of land disputes, that type of practice. We do call on them for their assistance so as to really grasp the events that have taken place. On the question now of minors or underage children, the director for the Childhood Affairs mentioned the legal provisions. I'll just like to tell you about the institutional measures we have and add a couple of points in that regard. On institutional measures, for 3 years now, we've set up the Judicial Police for Minors out in the 18 jurisdictions at the first instance level. We have a unit falling under the Magistrates Department. The aim there is to seek information and to verify children's data and draw up reports about adoption and the placement of a child with a family and a disappearance of a child. You have 2 magistrates for that and 1 assistant for the protection of minors. It's working in a specialized unit for the protection of minors, which provides support and assistance. Beyond those institutions, under the Ministry of Social Affairs and Microfinancing, there are specific services which socially, psychologically, and medically provide specific aid and assistance to support minors. If you wish, we could provide you with more specific information and details. Now, as I say, if you wish to have additional information, we can provide that in writing. Still on the question of minors, we have a practice in place which enables us to reach out to the grassroots local level to obtain more information about the respect for children's rights. We have a confederation of minors to feed that information into the Child Protection Office. This enables us to have a greater, more general protection to minors nationally and to avoid a number of conduct. But today, we do have this phenomenon of the departure, if you will, of minors who embark on other adventures abroad, in European countries in particular, and there we have to keep an eye on the situation. The issue of dissemination and awareness raising about the convention has been mentioned. In terms of planning, we have the Directorate for Planning, which is setting up a digital fund to make it possible to disseminate legislation in general and in particular the Convention on Enforced Disappearance. But we would need to incorporate within the training process the police, judicial office and magistrates. And we need to look at the specific context of enforced disappearance. There's a timeline in place to review training programs, and that's currently in the pipeline. So we will be able to give you specific responses on that, but we have a timeline at the beginning of the year, and by the 6th of October, we hope to have more information about the various issues for this year. I won't be able to tell you immediately whether the issue of enforced disappearance has been incorporated this year. It's often on the request of magistrates that we draw up the training curriculum. I think my time is up, but if I may, I'd like to take up a couple of more minutes to address another point. And this was to do with civil society in terms of freedom of expression and assembly, and also the protection of human rights. I'll give the floor to the Director for the Human Rights, who is in the room, to ensure and tell you that civil societies are fully involved in drawing up policies on human rights, and we fully cooperate with these NGOs in drawing up policies, the discussion of submission of reports, and a number of other areas. Given that we don't have enough time, if you may, or if you wish rather, we could get in touch with the technical services. On the freedom of expression, I don't think there's any restriction imposed on the freedom of expression, no restrictions on the freedom of assembly. No NGO is prevented from lodging a complaint or turning to a law enforcement mechanism to ensure the legitimate interests and rights of all persons. On the issue of the special rapporteur mentioned, I think I did deal with that when I mentioned the judicial body and the criminal brigade. Measures taken to deal with that situation have been measured, placement measures as well. I think we dealt with that. At the beginning of September, we have extended training to all health personnel, and we've incorporated birth certification processes, which also enables us to issue birth certificates to all individuals with a single ID number. Thank you, Chair. I think I've replied to all of the questions, but if I have omitted some, I remain at your disposal. Thank you very much.
Merci beaucoup.
Thank you very much indeed to you and to the entire delegation for the responses provided during this round. But as you said, we will, of course, give the floor to committee members and to the rapporteurs for some additional questions. And then you will once again have another opportunity to come back to a number of points, which have been already mentioned in greater detail. And you can give the floor to members of your delegation if you so wish. I'd now like to return the floor to the rapporteurs. And I'll start out with Mr. Diop. And dear colleagues, of course, if you want to take the floor, don't hesitate. Once again, thank you very much indeed, Chairman, and thank you also to the co-rapporteur who has allowed me to begin. I'll start out with addressing the question of non-refoulement and exclusion. Based on the explanations provided, this procedure is exclusively administrative in nature. And even though the appeal is suspensive, it is down to the administration to decide on the expulsion or not of the person. And I'm wondering whether there wouldn't be a need to have a judicial appeal to guarantee the lawfulness of the procedure. Because based on the responses provided, this isn't planned. Should one think about a judicial appeal to ensure the lawfulness of the expulsion decision? Now, as to custody, I do, however, still have a concern when I think of the time frame for custody lasting up to 8 days. 8 days of custody. Those 8 days, I think, occur at the police station, as far as I know. So for 8 days, the person is placed under police custody. Now, I'm wondering whether this custody is standardized for all offences. Is there a difference between a person who's prosecuted for terrorism and infringement of the security or safety of the state or rape? Is the timeline for custody 24 hours, and then that's extended I don't know how many times to reach 8 days? Usually the extension then would be extended 8 times to reach 8 days, or 7 times to reach 8 days. Don't you feel that this duration, which should have been brought before an investigating judge than rather a judicial police officer, 8 days of police custody, and this is my view, seems very long. I wouldn't dare to say excessive, but extremely long. Generally speaking, I hear about police custody lasting 24 hours, 48 hours, with an extension, 72 hours with an extension. And given the specific nature of the offence that's being prosecuted, drug trafficking or terrorism, we can go up to 72 hours given the complexity of the offence. But 8 days of police custody, well, Still on the issue of police custody, you say that the person placed in police custody is informed of their rights. In material terms, how does this actually happen? Is the person informed of their rights, the right to have a counsel, the right to defense? Does legislation make it possible to allow this person, if they don't have enough resources, to have access to counsel by an appointment ex officio of a lawyer? Because not everyone is in the same situation. Not everyone can call a relative and then a defense lawyer. I'd like to know whether the police, on the request of the person being held in police custody, can call on a relative or a lawyer. And I would also like to ask the same question regarding foreigners or aliens. When they are held in police custody, does the police get in touch with the consular authorities, or is it the person themselves who contacts the consular authorities? And perhaps now my last concern, or not really a concern, but request for clarification. I'd like to ask some questions about extradition. Now, based on what I've understood, there is a ruling authorizing an extradition, and this is taken by an investigating chamber, the appeals court, as far as I know. Is this ruling subject to an appeal before the Supreme Court? It could be the Court of Cassation, the Supreme Court, or the Constitutional Court. Now, I do get the feeling that the decision of the investigating chamber is referred to the President of the Republic, who immediately takes up an extradition decree. But is it the ruling from the investigating chamber? Is it subject to an appeal before the Supreme Court, whether it be the Supreme Court or the Court of Cassation? Thank you, Chairman. Minister of Justice, they were the concerns and questions I had. And if I don't have an opportunity to take the floor once again, I'd like to very much thank you for being with us, for being so sincere and honest, and your willingness. Thank you very much, sir.
Merci beaucoup.
Thank you very much indeed, dear colleague. I'd now like to give the floor to the second rapporteur, Mr. Juan Pablo Alban Castro.
Gracias, Presidente.
Thank you, Chairman, and thank you also to His Excellency and the rest of the Beninese delegation, both in the room and also from Capital, who provided us with important questions to the answers to the questions we raised. However, I would like to raise a number of follow-up questions or requests for clarification given the answers given to us just a few moments ago. Firstly, I'd like to ask the delegation about the criteria applied to assess the existence of a risk or a threat of a possible enforced disappearance in the case where a person is going to be returned to another state. In other words, how can you assess whether the person would be at a risk of being disappeared once returned to that state? That's my first question. And it would be important to clarify that. My second question, well, we're grateful for the information about the mechanisms in place so that a person deprived of liberty can maintain communication with their relatives. And it's also been said that open communication is maintained with their lawyers. But as a complement to that, when we're dealing with foreign persons who are deprived of their liberty, can they also have communication with their respective consuls? Is this facilitated in compliance with international consular norms and the possibility of consular assistance? Can they communicate with the authorities of their countries, basically? In addition to that, in the replies provided by the members of the delegation in Capital, it was said that Benin is committed to the fight against human trafficking. That is why it's decided to be a party to various international conventions and agreements, a legal framework has been adopted, and specific institutions have been set up to grapple with trafficking. And in the Criminal Code, Article 429 to 414 criminalize that offence, and there are prison sentences up to 20 years. But I'd like to know what prevention measures are in place for the phenomenon of people smuggling and trafficking. What measures are being implemented above and beyond the ex post when a case occurs? What measures is the country taking to prevent cases of trafficking from occurring? And I'd like also to have your position about the institutions in place. You say that a legal framework has been adopted and institutions have been established to address trafficking. What are the institutions locally who deal with the phenomenon of trafficking? Similarly, in the responses provided by Capital, it was said that in terms of international cooperation for the prevention of trafficking of children, that Benin has all institutions and structures to combat this type of threat, this risk of child trafficking. And once again, it would be important to know who those institutions are. What are they? What are those structures or those bodies which prevent trafficking, specifically child trafficking? In the responses, it was said that there isn't a concern about the forced recruitment of children. But above and beyond that, there are provisions in the criminal code which would make it possible to sanction this offence. And it's been said that the criminal offences under Articles 119 onwards and Article 469. And any practice of a forced recruitment of children or their use in armed activities may be considered to be a crime under those provisions. That's in Article 464. However, I was looking at the relevant provisions that you made reference to. Now, of course, recruitment of children isn't explicit in these provisions of the Criminal Code. And I'd like to voice a concern and ask a question, because from the standpoint of criminal legality, if the behavior, conduct isn't specifically described in the Criminal Code, in actual fact, we're dealing with an atypical act. In other words, it's an act that couldn't be sanctioned if the principle of lawfulness were upheld. And I'm saying this specifically because it was said that child recruitment could be tackled as a crime against humanity under Article 474 of the Criminal Code. But crimes against humanity require the existence of an attack, whether it be systematic or widespread, against the civilian population. And that's what the Criminal Code of Benin states. And in contexts in which there are no systematic or widespread attacks against the civilian population, how, in criminal terms, would you then tackle the issue of the forced recruitment of children? In other words, if this doesn't occur within a systematic or in a systematic or widespread fashion, how will that act be punished without violating the principle of lawfulness?
Se nos ha dado cuenta.
We also have heard of the unfortunate phenomenon of terrorist organizations infiltrating into your territory, which is there was the Mirador operation in order to tackle the challenge, and there are specialized police units in the cross-border area with Nigeria, also stationed there to address it. And then you also mentioned that there are difficulties between communities over land use or abductions for marriage, but that there are no cases of enforced disappearance. So the judicial police takes a role in that. However, what I had asked about has to do instead with how you address the matter of activities undertaken by armed groups in the northern reaches of the country. How can ethnic minorities be affected by these, and how might they be affected by enforced disappearances by non-state actors? And also in the context of the fight against these non-state actors, these criminal organizations, how do you ensure that innocent people don't end up being victims of this, referring to people of ethnic minorities, victims of many crimes, including enforced disappearance? So it'd be important to have clarity on what mechanisms are aimed at protecting the communities in the north and throughout your territory, given the terrorist threat that could come with these phenomena. For example, the terrorists, and also how the anti-terrorist efforts could affect these populations. Also, you have indicated to us that there have been no provisions, or you haven't looked at those participating in the investigations providing information. People can't provide in participation of trials against possible charges, but they can participate in the search processes beyond whether they provide information or not. Can they be present, for example, in these search efforts? Can they promote activities for specific searches beyond the information, beyond merely providing information to the authorities, referring to private parties there? Now, training. I have a follow-up question on training. I thank you for your information on the fact that there are plans in the Judicial Academy for training. It's still not clear what the timetable is for that, but those courses are slated to take place. So my follow-up question has to do with other non-judicial bodies. For example, security forces, the police, and the armed forces. Have you planned training programs in enforced disappearances for those groups, and general training on the provisions of the convention for other institutions that might have relevant remit? For example, your Human Rights Commission, the CBDH, training on the provisions of the convention. Now, lastly, so that I don't use all the time, and so that my other colleagues might be able to ask questions as well, I would like to insist on a point, because there's no clear information on the mechanisms that you're planning to implement, or that you are implementing, to address the cases of illegal adoptions in the past. Have you planned to create a search mechanism, a truth mechanism, or some reparation mechanism for the families that have been affected by these illegal adoptions historically? How do you ensure that civil society organizations that are supporting the victims of enforced disappearances can freely undertake their activities? Should there be, or might there be, any sort of limitation or limit on the victims or their organizations, or the victims' organizations publicly bring forth their complaints, explaining before the court of public opinion what their cases look like? And also, to what degree has the government of Benin consulted civil society, organized civil society, and the victims support organizations in the design of public policy that have to do with, for example, trafficking in persons and migratory matters that could lead to disappearances, the creation of victim support mechanisms as well in the case of disappearances? So these are matters that you've addressed, but that I was hoping to hear clarification on. So that's all I have right now. Thank you, Mr. Chairman. Thank you very much.
Merci beaucoup, chers collègues.
Thank you very much. Carmen Rosa, Madam Carmen Rosa, you have the floor. Good day. I would like to hail the presence of the minister here and also your team in Capitol. You have responded to a great many of the questions. I do have two very specific questions. You spoke of the transfers, the transfer of people from the north to the capital. Those transfers sometimes take a great deal of time because of availability of resources, et cetera, or weather. So during these transfers, has the state taken measures to preventative measures or specific measures to ensure that during these transfers, the individuals are not victims of, do not fall victim of enforced disappearance? It's not just the 8 days mentioned by my colleague, but rather during these transfers. I'm not sure how they're done. I'm not sure who undertakes them, in what conditions they are undertaken, and who is in charge of these measures to prevent enforced disappearance, because there are cases in which the transfer have led to a disappearance. Now, secondly, I would like to ask the following, and this in the wake of what we heard from my colleague, specifically addressing the cases of human trafficking in women. Has the state taken measures to provide special protection for women with a gender-based approach, a differentiated approach, as we see, at least in the case of women and also children, and the differentiated care there? So how do you incorporate the gender perspective into the disappearance of women, girls, or teens? Now, lastly, also, in addition to the list that you provided in your initial report on the women's associations and the laws on violence against women that have already been enacted by the state, what true mechanisms are, real mechanisms are there in place to prevent women from being victims of enforced disappearance? Thank you. That would be all, sir. That would be all, Your Excellency. Thank you. Thank you. Thank you very much. Would anyone else like to take the floor? Yes, you have the floor. I'm sorry, not just victims of enforced disappearance, but also victims of sexual violence. How are disappearances addressed, as well as the other crimes that might involve gender, crimes that are related to gender? Thank you very much. Thank you very much. I see no other requests for the floor. Yes, Mr. Diop. With your leave and indulgence, I will take the floor just quickly because a brief question has come to mind. A question that I asked yesterday had to do with the difference to be made between disappearance and status and being missing. I believe that in the next reform of the criminal procedural code, this might be addressed as well in the civil code, procedural code. I think it's important to draw a distinction between missing and disappeared, and the procedure that is put into place when there is a disappearance. That should bear in mind certain elements regarding the disappearance, whereas when it's a person who's missing, it's a different scenario. And it could be that in the case of missing individuals, a person might be deceased. However, someone who's been disappeared is in the hands of someone. So the circumstances are different. I think the procedures should be different. So the procedures in place for a missing individual, I don't think should be used in the case of someone who is disappeared. Thank you for the responses. Again, to our questions and concerns, I thank you kindly. Thank you very much. Thank you, colleagues. I have a complementary question as well. Turning to the issue of isolation or incommunicado detention. Someone had mentioned the decree of 2024. And yes, it is that decree that I believe is mentioned in the report from the special rapporteur. Would it be possible to have additional information on that reality? And as far as we're concerned, as the Committee on Enforced Disappearance, the question that we're wondering is about the compatibility of that decree with Article 20 of our convention, to be precise. It imposes very strict conditions on information. When there's an individual that is deprived of liberty, it should be only when that person is under protection of the law. There's a right to information under Article 18, and that might be limited exceptionally when the situation requires it, as regards, and when the transfer of information undermines the privacy or safety of the individual, or that could lead to a criminal, or because of a criminal investigation, in step with other legal provisions or international provisions, or under Article 20, when it comes to restriction on the transfer of information, as we see under Article 18. In such cases, there can be a judicial appeal. So in the case of this, more specifically, when there are such measures for isolation, the issue of the delay, I don't think it was clear. The special rapporteur did address this issue of that time period, and the special rapporteur did indicate that this was subject to a reform procedure, but during this isolation period, might the interested party under Article 18 effectively have access to information? What are the restrictions to having access to information? And if there are restrictions, and if there is a decision to not transfer information, might that decision be appealed? So the issue is one of compatibility between your judicial isolation policy with the with our instrument, with the convention. I think that also in general, we are very interested in giving the floor back to the delegation to address not just domestic legislation. We have heard your clarifications on domestic legislation and a great many other items. The state party seems in many regards very much in step with the convention, even if there might be some doubts brought up here. What we're interested in beyond national legislation is also the practice, what happens in practice beyond the legislative efforts. What's important is the effective implementation or enforcement of these rights that are set forth by this convention and other international conventions. Is there a possibility of perhaps hearing more examples of what's being done on the ground, including obstacles that you've faced in implementing national legislation? That would be very interesting, I think, for the committee, so that the committee could offer recommendations that are as concrete as possible, as targeted as possible, and so that we can participate in this active constructive cooperation between the committee and the state party. Thank you very much. I'm sorry, please. We have 4 more minutes, so Mr. Juan Pablo Alban, you have the floor. Thank you, Chair. Just a very specific item that I had forgotten to mention. Might you be able to clarify as regards the nullification of the adoptions? As I understand, there are different types of adoption, and there are some that can be made null and void, and others that cannot. So perhaps you can explain that as well. What types of adoption can be made null and void, or under what conditions can they not be made null and void? Thank you. Thank you very much. That is an item that was mentioned by the delegation in Cotonou, the distinction between revocation and nullification of adoptions. So that's another item that perhaps can be addressed. Be perhaps useful to circle back to that. And perhaps practical examples could also help us to understand this legislative distinction. Thank you very much. With that, I give you the floor, Your Excellency. Thank you. Now, on the issue of the nullification of adoptions, I think that what has been said is that there is revocation, but not nullification. And that has to be adopted in a plenary for simple adoptions or other types of international adoption. I think that regardless of other clarifications that might be provided, I would like to take the floor quickly on the concerns that were expressed by Mr. Diop. I'll begin with his last item. International law makes a clear distinction between the absence, between being missing and disappearances. This is covered in the Civil Code. It's in the Civil Code that we cover this this distinction back, and this has been in place for some time. So there's the missing phenomenon, and then that's different than we see as addressed in the convention. Enforced disappearance comes in the procedure of a criminal procedure, not civil, or at the hands of public authorities that have civilians in custody. So these are very different areas of law. It's important for us to distinguish that. And for each case, the missing falls into civil law, and there are a certain amount of rights in place. And this, again, are addressed in the legal provisions in place for civil individuals. Now, the question that we have before us here is enforced disappearance, and that is something that we have in two different legal corpuses. Crimes against humanity, which we mentioned, and all undermining of the law by authorities when it comes to freedoms enjoyed by citizens. So I think that on these aspects, indeed, we will be bringing these into conformity, both of these principles, crimes against humanity and other cases. This will be done in the criminal code. And I think that the discussion here actually has shed light on the need to address the notion of enforced disappearance and to take it out of the Article 465 and put it in a more general framework so that it can be better implemented. These are thoughts that I think that we will be able to move on quickly. Now, the issue of being held in remand, Article 18.4 of the Constitution, to give some context, sets forth that one individual can be held within 48 hours, that by decision of the magistrate, before which he is presented. So only 48 hours for remand. This period cannot be prolonged, cannot be extended, except under exceptional cases set forth by law, and cannot go beyond 8 days. So that's when the remand is extended as covered by Article 53 of the Criminal Procedural Code, and this has to do with economic matters for complex investigations, drug trafficking, terrorism, pedophilia, and sexual abuses. These are the cases in which we can extend that remand period. For terrorism, yes, we have to say that sometimes the 8 days are largely insufficient. So it's not just remand, it's actually a type of detention while the case is before the investigative judge. Again, this has to do with the investigative process. This is the period during which the individual has been held. First information is brought together, decisions are made so that the individual can be brought before the prosecutor so that the prosecutor can decide to prosecute or not, to continue or not with the investigation. So that's really the heart of the matter. The infractions that are, these cases are complex and often require mobilization of additional resources, and that depends a great deal on the technical and financial and human resources we have available in the judicial police. Sometimes the information, the adequate information needs to be provided first. A simple example to illustrate this, sometimes to ask for a bordering country, Togo, Nigeria, to ask for information from them, from intelligence information, sometimes that doesn't come to us within a 15-day period or even a 30-day period. These situations can arise. So we don't wait for the return of this, for the receipt of this information. We perhaps launch the judicial proceedings, and then the prosecutor could make a change to the decision on the detention later. So this is the information I can provide on remand. In remand, it is from when the individual has the right to a lawyer, when the lawyer provides all of the information, except when there are classified information. The idea is to be able to sometimes have the leeway to get information from abroad and ensure that the lawyer can undertake these efforts. And sometimes the individual as well can make specific requests that we see in the indicting documents. And it is the lawyer that can move on this. And this can be validated by a judge moving to prosecution, or this can launch appeals, etc. So these are the guarantees that have been provided. I think on this point, the Criminal Procedure Code in Benin is evolving as we see other countries evolve in our region and in Europe. Now, when an individual is found in a detention process, systematically, the penitentiary system in Benin has lists that are disseminated among diplomatic corps when there are consular matters to address. Individuals of another nationality in the hands of the justice system, those cases are automatically brought before the different relevant consular offices. And further, when individuals ask to visit the consular authorities, they're allowed to do so online. These are services that are available to all individuals. The penitentiary services and the judicial authorities make sure that this is possible in their efforts to prevent abuses and to respect the provisional detention mechanisms. You also mentioned the issue of what arrest warrants can look like. Sometimes this depends on the appeals court. Yes, it's possible for there to be to have these issued, and these can be reviewed by the Supreme Court. Now, the issue of refoulement, I would like to insist merely on the point that there are indeed judicial appeals processes. It's not administrative. The administrative decision is made by the ministries, the Ministry of the Interior in this case, and the Border Police, as well as immigration. But the appeal is brought before the administrative authorities. I'm sorry, before the judicial authorities in the administrative section. So the administrative judge addresses that, and that the due process is guaranteed to the individual for whatever the issue might be, whether it's a refoulement case or not. We have the option of making sure that this goes before the proper administrative bodies. And there is a possible to appeal, and there's the Court of Cassation as well, and then up to the Supreme Courts. That's organized. During these time periods, measures there can be a stay while the appeal is underway. Now, there's another question asked about communication and consular assistance. I hope that I have responded to that question from Mr. Alan Castro. If I have not addressed that fully, please do ask for additional clarification so that I can provide the response. Also, you wanted to know what the criteria are by which how do we gather information to evaluate the risk or dangers of enforced disappearance. On this point, I would like to note two elements. I'm going to be practical. First, whatever the individual indicates as an argument as regards risk of enforced disappearance as expressed to the justice system or the police. Now, also, all of the intelligence information undertaken by the state when there is perhaps an extradition matter or when the individual might be sent back to their state of origin. Sometimes with Interpol, we do determine whether there is concrete judicial information or information that can back the request for deportation and whether the comments from the individual, him or herself, can be brought to the foreign authorities so that the information can be either called into question or confirmed. That will allow us in our decision-making process to include all of that information. How do we ensure that terrorist groups, non-state actors, actions not affect minority groups and lead to enforced disappearance? I do not have a specific response. I don't fully understand the question, so I'm going to try to give a response given that. But if you have additional follow-up questions to shine greater light on this, I'd be happy to hear what that is. But I don't know of any cases of abduction so far, or kidnapping, even in terrorist activities. We do not have any. This situation has not been reported. Recently, there were similar circumstances, but the individuals that were abducted were automatically released not far from the place where the abduction took place. So this practice at the hand of terrorist organizations we have not seen. We do have these practices, but these are criminal activities, not terrorist activities. Sometimes these cases are linked to other types of criminal activity, and there the judicial police does get involved. Now, general protection provided to all groups. I think that there were some incidents with a specific community that is often involved in the infiltration of terrorist groups. The president of the Republic, the head of state, took a role here with that population in order to underscore the need for there to be training and transparency in the judicial process to the benefit of that community to address the issue of the protection provided them through numerous different decentralized mechanisms on the ground or otherwise.
In terms of search, we can exchange information with those bodies and intervene in areas where we don't have all the information, but these bodies cannot be officially incorporated into our procedures. But community intelligence, however, does allow us to better work, or for our police forces to better work, for our army to better work in certain areas that are remote or isolated or difficult of access. The association. So now on training and other services, you asked us if the police or other administration bodies are involved. Well, yes, the police is involved in the awareness raising training for judicial officials. These are often cross-cutting training programs organized by the Ministry of Justice for these aforementioned categories. But evidently, we need to do more to provide more information about the CED to better inform people and to ensure that people are given enough support and given enough information about the CED so that it is properly disseminated, put online. For example, we're ready to do that. I talked about the Ministry of Justice earlier on, having the digital fund and making that available to contribute to that. But there's one thing I really wanted to labor with you, and that's the following. It's not just a matter of the information being available. It's a matter of the information being reliable and accessible, because most of the public in our country doesn't speak French or English. So it's not only putting the information online, but it's also translating it, making it available to interpreters, so that people on the ground can properly understand in their own language or through interpretation or translation the content of these international instruments. So everything we can do to support that availability of these texts in the local dialects and languages will be useful. Now, we do that as best as we can, but if we really want to broadly disseminate this information, then we need to avail ourselves of all the support we can get to provide these texts in local languages, get the texts closer to grassroots. So that's what I wanted to say about dissemination, access to information. Now, unlawful or illicit adoptions and what has happened in the past, what is possible, what can be considered well, anything to do with search for information, anything to do with investigation, we are doing what we can to improve our approach to the search process, but at no point has there been any challenge, any opposition, any action by government to prevent an NGO to have access to information, to press charges, to file a complaint, to disclose publicly information about victims or communities whose legitimate rights might have been violated and who need the protection of the law. The government services are accessible freely, totally freely. So any concerns or fears you might have should absolutely be dispelled in our context. You raised other concerns about specific measures on gender. In connection with victims of enforced disappearances, you talked about special measures for women and a gender approach for children. We don't particularly distinguish between categories of victims currently in our public policies. We have mainstream gender in some of our investigation approaches, in some of our treatment or care processes or protocols. You talked about sexual or gender-based violence. Well, on that, we have a dedicated institution dealing with the rights of the women who provide services to provide legal aid and assistance, as well as other form of treatment or support to women and children who are victims, and to minors who are victims of enforced disappearances. But generally speaking, if you ask us if we have structured legally a gender approach, or if we mainstream gender in our processes, my answer to that would be no. We've got a general approach to meet concerns and worries, but that's as far as we have gone. And this is also something that allows me to address the matter of, at the investigation stage, when a lawyer is available, will we have legal aid procedures available with the Bar Association for eligible persons, namely people who are poor and who are registered as such and who are entitled to apply and receive the services, the support of a court-appointed lawyer. I don't know if I've exceeded my 2 minutes, says the speaker to the chair. But if you would allow me, I could give the floor to the room to elaborate on prevention and other concerns.
Okay, merci.
Absolutely, says the chair. Thank you. So we turn back to Cotonou. Ladies and gentlemen in Cotonou, remotely, do you have anything to add?
Essayer de rétablir la communication.
If the communication channels could be re-established. They are now back on the screen.
Bonjour, rebonjour.
Greetings once again to you in Cotonou, says the chair.
Bonjour, Monsieur le Président.
Good day to you once again. Yes, we can hear you very well, says the chair. Arnaud Tofoun, Director of Legal Protection for Childhood Affairs. On prevention of trafficking, much is being done, beginning with the Ministry of Justice, generally speaking, is proactive and every year carries out awareness raising and training for several stakeholders working in countering trafficking. And medical practitioners and tourism operators. We're very vigilant about sexual tourism in connection with trafficking. Awareness raising also for local elected officials who are at the forefront when it comes to the protecting victims and children. And also, we provide information to children about their rights and duties. We have 70 child ambassadors trained to actually do that. They're taught about their rights and they in turn teach their peers about them. The Department for Human Rights also engages in awareness raising activities on the ground. We need to develop and refine what we do under the wise and distinguished leadership of the Minister of Justice. I can also tell you that still on awareness raising. Awareness raising has been a priority in schools nationwide. We visited 20 schools nationwide from the north to the south in an endeavor to provide protection for children. Also, online surveillance of trafficking is being carried out by a specific body, specific institution, and institutionally at administrative and judicial institutional level, there are things being done. First of all, with the administrative structures, we have a ministry to combat trafficking, dedicated one. And as the Minister of Justice rightly said earlier on, we have the INF, the Ministry for Women's Affairs, defending the rights of women and girls. So from that point of view, the protection of that category of citizens is protected by this institution. We also have the formal institutions of the Ministry of Social Affairs, which has a social protection unit. We have the technical directors, the OCPLME, a body of the Ministry of Ministry of the Interior and Public Security, whose job is to combat trafficking. From a judicial point of view, also, we have all of the courts and the tribunals, the CREET, and all the judicial bodies combating trafficking. Also to be noted is civil society. We have several civil society organizations. RAO is just one of them. RESPED is another, and we have several other NGOs. FOTEB also. The sound is not good enough for the interpreters to get the acronyms. So we have several civil society NGOs who work specifically in preventing trafficking. With regards to care structures or treatment structures for victims of trafficking, we have a number of different centers. And now focusing specifically on treatment for victims, because when you speak about treatment, you also need to talk about care provided for victims or treatment provided for victims. We have dedicated centers for the treatment of children who are victims. They're called host and protection centers. Also, all of our centers for the protection of children and adolescents who have been made operational and are supporting children who are victims. We also have the center to host children in transit. We also have other bodies. Supporting victims of trafficking from 1 month to 3 months stays. On recruitment now, under Article 203 of the Childhood Code, the use of children in armed conflicts is tantamount to exploitation. Article 204 also applies, as does Article 464 of the Code of the Criminal Code, rather, which covers prosecution for crimes against humanity. To conclude, adoption, you asked us about the difference between the different kinds of adoption. Simple adoption, namely the person stays in their biological family. But the second kind of adoption is adoption wherein the child leaves the biological family and lives with their host family. Adoption is irrevocable. However, if it comes to light that the adoption took place following an enforced disappearance, then we can call for that adoption to be reversed or annulled. Thank you.
Merci, Monsieur le.
Thank you, Inocencia Montero, Director for Cooperation and Mutual Judicial Assistance. Inocencia Apovo Monteiro. May I add to what has just been said? In preventing trafficking, we carry out many activities on capacity building for key stakeholders involving in combating this phenomenon, namely criminal investigation officers, CIOs, as well as judicial officials, as well as the court registrars and others. Very often, we involve also civil society organizations, as well as local elected officials, as well as traditional leaders, religious leaders, so that the information we have is truly passed on to the grassroots. Awareness raising is also done about legal texts adopted in Benin, and this through the traditional media and current social media in local and traditional languages, so that we can reach as many people as we can. On an operational level now, what do we do? Well, let me begin by saying that given that we're aware of the vulnerability, the porousness of our borders, we have done much to strengthen security there, to proactively control or monitor the movement of people at risk of being trafficked, in particular women and children. So we've strengthened our border controls. Domestically, very often we have unannounced visits by the police in bars and hotels on the basis of tip-offs, thanks to which we are able to dismantle criminal networks, and that has a deterrent effect on potential traffickers. My person who spoke before me mentioned the use of social media and our monitoring thereof online to monitor actions of traffickers, especially when they seek to recruit young people. That most of the time it happens online. But this monitoring we operate also concerns financial flows, because at the end of the day, people trafficking is very profitable. So we have two specific financial monitoring bodies intervening and undermining the financial flows of traffickers. So on cooperation now, regional and international cooperation, we are very proactive. We have many agreements, especially we've also signed regional bilateral agreements, for example, with Gabon, with Congo, because these are countries where victims of trafficking are sent. So these agreements exist. We are planning to broker an agreement with Kuwait, where many of our citizens end up, thanks to which we have been able to strengthen what we do to combat this phenomenon and to proactively identify the victims thereof, to provide assistance to them. The government of Benin has also been intervening to tackle the root causes of this phenomenon, and the Ministry of Social Affairs and Microfinancing, the MAS, has been providing aid to the vulnerable through the provisions of funds and other activities to support disinherited families, for example, and that is a way of us tackling the deep causes of these phenomena, so that departures can be lessened. May I dwell briefly on the Central Office for the Protection of Minors and the Family, and to suppress people trafficking, which is a unit of the police force in Benin, and which has an integrated center to provide care for victims. This office is now decentralized into 3 departments of the country in order to be able to cover the whole of our territory. Thank you for your kind attention.
Nous retournons la parole, s'il vous plaît, au garde des Sceaux. Merci.
We would like now to give the floor back to the Minister of Justice in Geneva.
Merci beaucoup. Donc, je voudrais juste sur ce point conclure qu'il y a à la fois.
Thank you. On that, we have a legal and an institutional mechanism in coordination, in cooperation with various ministers under the leadership of the Ministry of Development and Governmental Action. And we have the cell of the Ministry of Justice with a number of technical directors. We have the cell or the unit of the Ministry of the Interior and the Benin Agency for the monitoring of borders, the BGF, and a number of other units, governmental units, which monitor exits and entries. And we have a coordination office with our stakeholders on this institutional cooperation and this cell to combat people trafficking. That's what I wanted to add to what's been said.
Merci beaucoup, Monsieur le Ministre.
Thank you very much, Minister. And thank you to you and all the members of your delegation to respond to questions put by members of the committee. We are moving on to the end of our dialogue, and in that connection, for a final statement, concluding statement, may I give the floor back to the Minister of Justice of Benin. You have the floor, sir.
Monsieur le Président.
Chair, thank you. Rapporteurs, Excellencies, ladies and gentlemen. Over the last 24 hours, yesterday afternoon and this morning, we have discussed at length the implementation in Benin of the Convention against enforced disappearances, enforced and involuntary disappearances. We have, to the best of our ability, endeavored to answer all of your questions, to explain to you what we were doing to meet our obligations under the Convention. We have noted the various points you have raised as to how we should improve what we do. And we look forward very much to the recommendations you will be making to us that will help us to improve our performance under the CED. On that point, may I renew our entire availability and readiness to renew our commitment to the CED that goes beyond the mere existence of the CED in our domestic law. I can assure you that all the recommendations you give us will help us to better enforce the CED in Benin. Chair, ladies and gentlemen, thank you very much. It has been an honor for us to be involved in these discussions over the last 2 days. Thank you very much.
Merci beaucoup, Monsieur le Ministre.
Thank you very much, Minister, for this concluding statement. Excellencies, distinguished colleagues, ladies and gentlemen, may I thank once again all of the delegation of Benin, through the Minister of Justice and the Keeper of the Seals, for your respective presentations and answers to our many questions. You've done so in a constructive spirit, and that is always the spirit which suffuses this dialogue. May I thank in particular the two rapporteurs for the significant work you've done to prepare this dialogue. May I avail myself of this opportunity also to thank the Secretariat for its support and to thank Conference Services for having set up this connection between Geneva and Cotonou, thanks to which we've been able to have a section of the delegation participate remotely. Of course, thank you to the interpreters for what they have done to make it possible for all this information to be properly communicated, including through this hybrid setup, which doesn't make their life easier. Of that we are aware. Through this dialogue, we've turned a very important page in terms of cooperation between the State Party and the committee. We are now going to get down to the task of drafting our concluding observations, which we will be adopting before the end of our session. The delegation has an additional 48 hours to send to the committee any additional information in writing it deems important or on matters that weren't covered during the dialogue. Once we have adopted our concluding observations, a unedited provisional version thereof, a draft, will be sent to the State Party, who will then have 24 hours to correct any factual mistakes, namely names of institutions or people or figures that might need to be corrected. So factual errors within 24 hours working day. Once that the final information is sent to the State Party, we will move on to the implementation phase of the recommendations made, and that will happen through our procedure to request for additional information provided for in Article 29, paragraphs 3 and 4 of the CED, because you will be well aware of the fact that other conventions do not have, rather, if you do not have a periodic review system, very often these conventions have this procedure to ask for additional information about how our recommendations have been implemented in the light of information that might have reached us about the situation prevailing in the country. The deadlines for the submission of this additional information, if we were to be requesting them of you, will be set down by the committee, which will ask the state to kindly provide this information, follow-up information or complementary information. So we will tell you about the deadlines. These meetings, these reviews, are an opportunity to constructively discuss matters. We have the same aim at the end of the day, which is to guarantee an effective implementation of the Convention in Benin and in all other countries or states that are parties to the Convention. Please do not hesitate to contact us if you have any questions about how to implement our recommendations or any matter pertaining to enforced disappearances and the implementation of the articles of the Convention. We are, needless to say, available to you, as is the OHCHR and the independent experts who are members of the CED, who cooperate with all states, parties, and victims of enforced trafficking and civil society organizations to meet that particular objective. Once again, thank you to you all. My thanks go to the delegation of the Benin, and with this, I adjourn this meeting.
you.